நிறைய ரீசெண்டான டாக்டர் டோனி பவுச்சியோட இது வந்து பார்த்தீங்கன்னா கெண்டகி, இந்தியானா, டெனசி அண்ட் ஓஹயோவில் வந்து கண்டிப்பாக கேசஸ் கோயிங் டு கோ அப். நெக்ஸ்ட் 4 weeks பார்த்தீங்கன்னா there will be more cases அண்ட் அவருடைய இதுபடி பார்த்தீங்கன்னா நியூயார்க் மாரி நம்பர் ஆஃப் கேசஸ் நிறைய வர வாய்ப்பு இருக்கு அப்படின்ற மாதிரி சொல்லியிருக்காரு. அதனால நம்ம எதுவுமே தெரியாத பட்சத்துல நம்ம வந்து இன்னும் நம்ம நம்மளால என்ன முறைகள் ஃபாலோ பண்ண முடியுமோ அதெல்லாம் ஃபாலோ பண்ணி தொடர்ந்து இது பண்ணா நல்லா இருக்கும். அதுல முக்கியமானது பாத்தீங்கன்னா கண்டிப்பா மாஸ்க் தான் நீங்க எல்லாரும் போட்டிருக்கீங்க. நான் நிறைய பேரை பட்டேல் பிரதர்ஸ்ல பார்த்துருக்கேன். எல்லாரும் மாஸ்க் அண்ட் கிளவுஸ், தட் இட்ஸ் ஒன் ஆஃப் த பெஸ்ட் திங் டு கண்டினியூ ஆன். அது வந்து நீங்க எல்லாரும் பண்றீங்க. தயவு செஞ்சு எந்த ஒரு காரணத்தையும் அது விட்டுறாதீங்க, தொடர்ந்து பண்ணுங்க. ரெண்டாவது ஹேண்ட் சானிடைசிங். அதான் வீட்டுக்கு வந்தாலும் வெளியில போனாலும் நீங்க எல்லாம் பண்ணிட்டு இருக்கீங்க, அதை நம்ம புதுசா சொல்ல வேண்டியதில்லை. இப்ப புதுசா கொஞ்சம் ஃபேஷியல் கவரிங்கும் சொல்ல ஆரம்பிச்சுட்டாங்க. கண்ணை மெயினா ப்ரொடெக்ட் பண்ணணும்னு சொல்லிட்டு இருக்கிறாங்க. எங்களுடைய மெடிக்கல் செட்டிங் எல்லாம் பாத்தீங்கன்னா முன்னாடி அதை வந்து ரொம்ப இன்சிஸ்ட் பண்ணலப்ப, இப்ப கடந்த 2 வார காலமாக வந்து பாத்தீங்கன்னா காகுல்ஸ் போட சொல்றாங்க, ஃபேஷியல் ஐ ஷீல்டு போட சொல்றாங்க. ஸோ அதே மாரி நீங்களும் கொஞ்சம் முடிஞ்ச அளவு உங்க கண்ணெல்லாம் ப்ரொடெக்ட் பண்ணுங்க. வெளியில போகல ஏதாச்சும் சன்கிளாஸ் இது மாதிரி போடுங்க. ஏன்னா கண் வழியாகவும் இப்போ கொஞ்சம் நிறைய சான்சஸ் வருது அப்படின்னு ஏற்கனவே சொல்லியிருந்த பாயிண்ட் தான் அது. இருந்தாலும் இப்ப கொஞ்சம் அதிகமா இருக்குன்னு சொல்லிட்டு இருக்கிறாங்க. அதுவும் ஃபாலோ பண்ணுங்க. அப்புறம் சோஷியல் டிஸ்டன்ஸ் தான் ரொம்ப ஒரு காம்ப்ளிகேட்டடான சுச்சுவேஷன். நம்ம தான் ஆல்மோஸ்ட் 6வது மாசத்துக்கு என்டர் ஆகிறோம். கண்டிப்பா மன உளைச்சல்ல கண்டிப்பா அது ஒரு கஷ்டமான ஒரு விஷயம்தான். அதை வந்து எப்படி பண்ணணும் அப்படின்றத நீங்க கண்டிப்பா நம்மளுடைய மாகாணத்தினுடைய விதிமுறைகளை கண்டிப்பா ஃபாலோ பண்ணுங்க. அது மட்டும் இல்லாம ஃபெடரல் கவர்மெண்டோடையும் சிடிசி என்ஐஹெச்சோட வழிமுறைகளை நீங்க என்ன சொல்றாங்களோ அது வந்து எல்லா இடத்துலயும் எல்லா தளங்கள்லயும் அவைலபிளா இருக்கு. அதை ஃபாலோ பண்ணுங்க. பட் ஒண்ணு மட்டும் நான் சொல்ல விரும்புறேன் என்னன்னா, இப்ப ரீசெண்டா நான் பார்த்த ஒரு மீடியால வந்து நியூ ஜெர்சில வந்து பாத்தீங்கன்னா ரீசெண்டா நியூ ஜெர்சிலேயே ஒன் ஆஃப் த ஸ்டேட் ரொம்ப கம்மியா இருக்குன்னு சொன்னாங்க. இப்ப எல்லாம் அவங்களும் கேசஸ் ரைஸ் ஆக ஆரம்பிச்சிச்சு அப்படின்னு சொன்னாங்க. நியூ ஜெர்சி கவர்னர் மர்ஃபி வந்து என்ன சொன்னார்னா, நேற்று பாத்தீங்கன்னா ஒரு மீடியாவில் ஒன் ஆஃப் த ரீசன் ஒய் அவங்களுக்கு இவ்வளவு தூரம் அதிகமாயிருக்கு அப்படின்னு பாத்தீங்கன்னா ஹவுஸ் பார்ட்டி அப்படின்றாங்க. ஸோ அது வந்து நான் வந்து இதா சொல்ல விரும்பல, நெகட்டிவா சொல்ல விரும்பல. பட் வாட் வி டூ, நம்ம வந்து ஒரு குடும்பமா மீட் பண்ணாலும் 2 குடும்பம் 3 குடும்பமா மீட் பண்ணாலும் தயவு செஞ்சு அதையும் ஃபாலோ பண்ணுங்க. ஏன்னா இப்போ ரீசெண்ட் ட்ரெண்ட் வந்து நியூ ஜெர்சில வந்து ஒன் ஆஃப் த டேட்டா தே ஃபவுண்ட் தட் மோஸ்ட்லி பார்த்தீங்கன்னா ஹவுஸ் பார்ட்டிலேருந்து தான் நிறைய பேர் வருது அப்படின்னு சொல்லிட்டு இருக்கிறாங்க. ஸோ அதை கொஞ்சம் தயவு செஞ்சு நீங்க எல்லாம் பாருங்க. அப்புறம் நிறைய சோர்சஸ் அவைலபிளுங்க எல்லா இடத்துலையும் உங்களுக்கு தெரியும். புதுசா நான் எதுவும் சொல்ல விரும்பல. பட் ஒரு சங்கம் அப்படின்ற சார்பாக இதை வந்து ஷேர் பண்ணிக்கிறேன். அதே மாதிரி உங்களுக்கு எந்த கஷ்டங்கள் எனி டைம் ஏதாச்சும் உங்களுக்கு கஷ்டங்கள் இருந்ததுன்னா உங்களுக்கு தமிழ் சங்கம் உதவியா இருக்கும் அப்படின்ற பட்சத்தில் கண்டிப்பா என்னையோ எங்களுடைய 12 கழக உறுப்பினர்களை நீங்க எந்த காரணத்தை கொண்டும் தயங்காம எப்ப வேணாலும் நீங்க அணுகுங்க. எங்களால முடிந்த உதவியை எங்களை கண்டிப்பா செய்வாங்க. என்னுடைய 2வது இது வந்து பாத்தீங்கன்னா, இந்த ஒரு இக்கட்டான சூழ்நிலையில நாம வந்து இங்க இருக்கிறோம். நம்ம உறவு முறைகள்லாம் எல்லாம் ஊர்ல இருக்குதுங்க. எல்லாரும் நிறைய பேரு நிறைய குடும்பத்துல வந்து பெற்றோர்கள் வந்து நம்மளை விட்டு விலகி போற தருணத்துல நிறைய பேர் இருந்திருக்கிறோம். இந்த வாரம் கூட கேள்விப்பட்டேன், ஒரு நம்மளுடைய மெம்பரோட ஃபாதர் வந்து தவறி போயிட்டாரு, அவரால் போக முடியலன்னு சொல்லிட்டு. அது மாதிரியும் கடந்த 2-3 வாரமா நம்ம தமிழ் உறுப்பினர்கள் குடும்பங்கள்ல அது மாதிரியான நிகழ்ச்சிகள்லாம் நடந்தது. அதை கேட்டு நாங்க எல்லாம் தமிழ் சங்கம் சார்பாக ரொம்ப வருத்தப்படுறோம். அதே மாதிரி அந்த இறந்த உள்ளங்கள் எல்லாருக்கும் அவங்களுடைய ஆன்மா சாந்தி அடைய தமிழ் சங்கத்தின் சார்பாக இறைவனை வேண்டுகிறோம். ஸோ 3வதா என்னன்னா, தமிழ் சங்கம். எங்க தமிழ் சங்கம் என்ன போகுது எல்லாமே நீங்க உங்களுக்கு தெரியும். உங்க ஒர்க்கும் சரி, நம்ம சோசியல் லைஃபும் சரி, எக்கானமியும் சரி, பிசினஸ் மாடலும் சரி, எல்லாமே ரொம்ப மாறிக்கிட்டு இருக்கு. அந்த தொடர்ந்து இந்த கொரோனாவுடைய தாக்கம் அதிகம் இருக்கிறதுனால நமக்கும் என்ன நடக்க போகுது அப்படின்றது எந்த லெவல்லையும் யாருமே எதுவுமே ஒரு இதா சொல்ல முடியல. தமிழ் சங்கத்தை பொறுத்தவரையும் அமெரிக்காவில் இருக்கிற பெருமையான தமிழ் சங்கம் எல்லாம் என்ன பண்றாங்கன்னா ஆன்லைன்ல தான் ஆரம்பிச்சிருக்கிறாங்க. ஸோ நாங்க வந்து ஒரு இந்த மாதிரி நிலைமை தொடர்ந்து நடந்துட்டு இருக்கிறதுனால ஒரு 4-5 வாரத்துக்கு முன்னாடி நாங்கெல்லாம் செயற்குழு உறுப்பினர்கள்லாம் கூடி ஒரு ப்ரொபோசல் பண்ணோம். சரி நம்ம ஆரம்பிக்கலாம், ஏதாச்சும் ஆன்லைன்ல ஆரம்பிக்கலாம். ஏன்னா நம்ம லைவ் ப்ரோக்ராம் இப்போதைக்கு பண்ண முடியாதுன்ற ஒரு தருணத்துல ஆரம்பிக்கலாம்ன்ற அந்த முயற்சியில தான் அதை ஃபர்ஸ்ட் ஆரம்பிச்சிருக்கோம். அதே மாதிரி அந்த தருணத்துல வந்து கமிட்டியோட நம்ம மெம்பர்கள் பார்த்தீங்கன்னா பாதி பேர் பர்மனண்டா ஓரளவு கிரீன் கார்டு சிட்டிசன்ஷிப்ல இருக்கிறாங்க, இன்னும் பாதி பேர் வந்து விசா நிலைமையிலையும் இருக்கிறாங்க. அவங்களுடைய துயரங்கள் வந்து ஒன் ஆஃப் த இது வந்து இமிகிரேஷன் ப்ராப்ளம் அப்படின்ற ஒரு காரணம் வந்து எங்களுக்கு இது பண்ணானாங்க. அதனால தான் இது வந்து இந்த டாப்பிக்கை ஃபர்ஸ்டா எடுத்து நாங்கள் இது பண்ணியிருக்கோம். இது அடுத்த மாதம் ஒரு குழந்தைங்களுக்கு எல்லாரும், குழந்தைங்களும் சரி பெரியவர்களும் சரி நடந்து கொள்கிற மாதிரி ஒரு கல்ச்சரல் போட்டி ஒன்று, கலை நிகழ்ச்சி ஒன்று நடத்தலாம், ஆன்லைன்ல நடத்தலான்னு ஒன்று பிளான் பண்ணியிருக்கிறோம். அது முடிஞ்சு ப்ராப்ளி ஒரு டாக்டருடைய நேர்முக இது மாதிரி கான்ஃபரன்ஸ் ஒன்று வைக்கலாமா அப்படின்னு ஒரு இதுவும் நினச்சி, ஏன்னா எல்லாருமே வீட்லேயே அடங்கி போய் நிறைய பிரச்சனைகள் அது இதுன்னு இருக்குது. அதனால ஒரு டாக்டருடைய இதுவும் வைக்கலாம்னு ஒரு பிளான் பண்ணியிருக்கோம். அது முடிஞ்சு தீபாவளி பொங்கல் வருது. அதுக்கிடையில அடுத்த ஆண்டுக்கான தமிழ் சங்க எலெக்ஷன் வர வருதுங்க. அதுவும் நம்ம புது கமிட்டி உருவாக்கத்துக்கான எலெக்ஷனும் வரும். அதெல்லாம் நம்ம முடிந்த அளவு ஆன்லைன்ல தான் பண்ண போறோம். அடுத்தது நீங்க பாத்தீங்கன்னா எப்ப லைவா பண்ணுவோம் அப்படின்னா, இப்ப இருக்கிற நிலைமையில பாத்தீங்கன்னா அடுத்த 21ஆம் ஆண்டு தமிழ் புது வருஷம் மட்டும் மேபி நம்ம அந்த டைம்ல வந்து ஆன்லைன்ல லைவா பண்ண முடியுமா அப்படின்ற ஒரு தருணத்துல தான் இப்போதைக்கு இருக்கிறோன்னு வச்சுங்களேன். அது வரையும் பாத்தீங்கன்னா இருக்கிற நிலைமையில நம்ம நேரா கூடி ஒன்று கூடி லைவ் ப்ரோக்ராம் பண்றது வந்து சாத்தியமானதாக இல்லைங்க. அதுதான் தமிழ் சங்கத்தின் சார்பாக நான் சொல்ல விரும்புறது. நீங்க வந்து எனிதிங், அதான் இந்த தமிழ் சங்கம் ஆன்லைன்ல தான் பண்றோம் அப்படி இருந்தாலும் உங்களுக்கு எனி தேவைகள் நீங்க எந்த காரணத்தை கொண்டும் தயங்காம எங்களுடைய 13 பேரையும் எப்பொழுது வேணாலும் நீங்க தயங்காம காண்டாக்ட் பண்ணுங்க, உங்களுக்கு தேவையான எந்த உதவிக்கும். நம்ம அடுத்து இந்த ப்ரோக்ராமுக்கு மூவ் பண்ணலாம். ஓப்பன் அப். ஸோ டுடே வந்து நம்ம சொன்ன மாதிரிங்க அதான் இமிகிரேஷன் அண்ட் ஐ எம் கோயிங் டு இன்ட்ரடியூஸ் அவர் ஸ்பீக்கர் ஃபார் த டே. Madhavi Samutrala is our speaker for the day today. She is practicing actually immigration law for last 12 years. She did her undergrad from government law college in Mumbai. Subsequently, she underwent a postgrad in law in University of Temple University in Philadelphia. She was admitted to New York Bar in 2008, and currently she is practicing in Dallas. I hope she will, will be able to deliver, able to clarify all your questions and any clarification you needed. On behalf of Kentucky Tamil Sangam, I welcome Madhavi to take over this program and present her talk today. Thank you, Madhavi. The conference is yours now.
Thank you, Mr. Senthil. Thank you very much for hosting this. I hope I can, present this and provide some information to the community. Also, if I see questions coming up, definitely I will answer all those questions at the end of the presentation. But right now, I'm just going to present. Thank you once again, Mr. Nambia. Should I just the slides, should I just upload them?
No, Nambi, are you able to screen play her slide?
I think you can do it, Madhu. You can present. Okay. If you click the present now, and then you can do the presentation. If you face any technical problems, probably then I'll take over from here.
Okay, present now, and then I can just share it.
Yeah, if you do a bottom present now, and then you can start sharing the screen.
Okay. Choose what you would like to share. sure if I can. I think I'm not able to share for some reason. I did present now. Okay.
Nambi, are you able to bring into screen on the slides, the PowerPoint slide?
Maybe I'll do that. Okay, let me start sharing a presentation here.
Okay. Thank you very much, Nambi.
Yeah, everybody can see the screen, right?
Yes.
Yeah.
So I think you just need to scroll up. Firstly, I'm just presenting a broad overview of the immigration categories that's there, because I didn't really have an agenda, and then I will just go on to some of the recent immigration updates and recent immigration things that have been happening with regard to the present administration too. So I know most of them you are aware, but anyways, Nami, can we get on to the next slide, please? Yeah, so basically there are two types of visas, of course. One is the immigrant visas, which are commonly referred to as green cards, and then the non-immigrant visas. So green cards also are based on two categories. One, you can get a green card to a family-based immigration or an employment-based immigration. With regard to non-immigrant visas, it's usually for a temporary purpose that you're coming to the US for a specific reason and for a period necessary to accomplish that purpose. There are almost 18 to 19 categories of non-immigrant visas. They are assigned from A to the letter T. So there are different categories. You might know some of them. It's an F visa for students, F, J, and M visa for students. Visitor visas come on usually B1, or business visa holders come on visitor visas come on B2, business visa holders come on B1. Of course, you have the non-immigrant work visas, which are H and L. For Canadians, we have the TN visa. And for Australian citizens, you also have the E3 visa, which is similar to an H1B visa. So there are different categories of visa, and you can, for temporary purposes, you have the non-immigrant visas. On the permanent side, you have the family-based or the employment-based visas. Number. So in the family-based immigration, there are certain categories. Because they, just like the employment-based, even the family-based immigration, some categories don't have any waiting period. For instance, immediate relatives, that is spouse and US citizens, spouse and children, unmarried children under 21 of US citizens. They're categorized under immediate relative categories, for which there is no waiting period, no numbers, nothing, and they can be processed much quicker. Also, the parents of US citizens are included in the same category, and most of these people get their immigrant visas within 1 year. The second category is the F1 visa, F1 category, which is for unmarried children over 21 years of US citizens. So there is a waiting period, and we usually refer to the visa bulletin to see whether numbers are current or no for such categories. F2A, which is for spouses and unmarried children under 21 years of green card holders. Again, the waiting period for this was once upon a time almost 2 to 3 years. And now in the past, we have seen that this has come down drastically to less than 6 months. So these visas once were very backlogged, but now it's much better with the F2A category. The F2B is for unmarried children over 21 years of green card holders. Children who might have aged out and they were earlier in F2A are automatically converted to F2B. Once a child is converted from F2A to F2B, he or she still retains her priority date. So it's not too bad. Of course, the F2B has longer waiting period, but if they are converted from F2A to F2B, then their waiting period is drastically reduced. The F3 category is for married children of US citizens. Usually the married children can come along with their spouse, as well as all their children who are under 21. Of course, if any child ages out, then there are the Child Status Protection Act provisions, which might be helpful in those cases. For F4 is for siblings of US citizens. Again, it's just not the sibling, even the spouse and their respective children who are unmarried and under 21 can come along with the principal applicant. This is for the family-based immigration. The employment-based immigration, again, we have 5 categories. EB1. EB1 is for workers of extraordinary ability or outstanding professors and researchers, as well as multinational executives and managers. Usually EB1, people who have come here on L1A visa might be eligible to get their green card under the EB1 category. So that is an option that some companies who have an office outside the US and also an office in the US would consider for their management and executive positions. EB2 is for members, somebody who has either the position for EB2 is somebody with an advanced degree. For instance, somebody who has a master's degree and the position requires master's plus certain years of experience, or maybe a bachelor's degree plus 5 years of experience. So those individuals fall under EB2, which mostly I've seen a lot of our Indian professionals would fall under the EB2 category. EB3 is for skilled workers, professionals, and other workers. Skilled workers is a category where the position requires somebody with 2 years of experience. Professionals are somebody who has a bachelor's degree and a certain number of years experience, maybe 1 or 2 years. And the other workers are people who require less than 2 years of experience. So all these 3 categories fall under the EB3. EB4 is special immigrants, people who can get, like, for instance, religious workers, workers from who are for temples or churches or any other religious organizations can get their green cards under the EB4 visa. EB5 is, of course, employment creation investor visa, which as of December 2019, the investor visa amounts have gone up. Earlier, the investor visa was if you invested 500,000 or 1 million, depending on where you're making that investment, you would get a green card for you and your entire family. Now those amounts have gone up to 900,000 and 1,800,000. So that's pretty, and also the investor visa at one point of time was very quick. Now we understand that this might be, this might take several years, like the EB2 visa, to get your green card under this particular category. Nami? So I'll just go on to the recent immigration updates that have been happening due to the COVID situation. These are based on clients calling me, asking me questions because of the unprecedented COVID situation that was supposed to be for a couple of months, and right now we see no end to it right now. So we don't know exactly when things will be back to normal. So one of the things that people have come up with is, of course, people who are visiting US, parents or have been visiting their children, grandchildren in the US, and they are currently on B2 visitor visas. So the situation with them is because, as most of you know also, that India is currently suspended all the international flights until August, end of August actually. So because of that, people are kind of stuck here, and there are some charter flights going on, but when you're stuck here, there's nothing much you can do. So USCIS has said that they will be flexible in having people here on visitor visas to extend their visas. They are, of course, now there are a lot of people who have filed their applications for extension of B2 visas. One good thing is the B2 visas can be extended online. You don't have to send in a paper application. You can file the application for extension of your B2 visa status online. The form to be completed, of course, is I-539. So USCIS has been reminding the public that it is a good idea, do not overstay. But if your I-94 is expiring, please consider filing for extension, because that will at least not, if you don't file for an extension and if your I-94 expires, that results in automatic revocation of your visitor visa, even though that has been valid for 10 years. So that is one thing people who in the B2 visa should be mindful of. The other one is RFEs and notice of intent to deny or notice of intent to revoke. Usually RFEs, USCIS provides 87 days, and for notice of intent to deny or notice of intent to revoke, USCIS provides a period of 30 days. However, USCIS has advised us that any RFE or NOID or NOIR that is issued after March 1, 2020 and up till September 11, 2020 they will get an additional 60 days over the period that USCIS has mentioned in the letter to respond to the RFE. I have seen sometimes people need to get documents from India. Sometimes there's a delay in getting documents because of the current COVID situation. And this really helps us to have additional time so that we can provide a proper and complete response to the RFE or the notice of intent to deny or revoke. The other one is signatures on forms. Earlier, any form that you filed with the USCIS, USCIS insisted on having the original signatures on the form. Right now, USCIS will accept scanned copies of the signatures. You can't have the digital signature on the forms. We have seen cases being rejected when the forms have digital signatures. So USCIS wants you to sign the forms and then they can have the scanned copy or a copy of the form mailed to them. This is very helpful for us attorneys, because if we're not going to our offices and clients are not coming out, they are in quarantine right now. So it's easier for them to just scan those documents to us and we can represent the clients based on the scanned copies of the signatures. The other thing is biometrics. Because of the COVID situation, the ASC centers, the application support centers where the biometrics were done, this fingerprinting, the photographs, everything was done, were closed down up until July 23rd. Effective July 23rd, these centers are slowly opening up, and we are seeing appointments coming in. Earlier for EADH, for EADs, USCIS had indicated that they will just go ahead with the biometrics that are on file and process those cases. But of late, we are seeing now that they are holding back those cases since the ASC centers are now open, and they are going to be scheduling new biometrics appointments for individuals. So biometrics are going to be back in place since the USCIS office is now open, and they will start scheduling interviews. The other thing about interviews, with regard to some of the cases where interviews have to be scheduled, we are seeing interviews being scheduled for December or January 2021. So there is definitely going to be a long waiting period for some, like suppose a US citizen has files for the spouse, and we have seen those cases will not be adjudicated without an interview because the USCIS officer has to interview both the husband and the wife. In those cases, right now, most of the attorneys are seeing interviews being scheduled in December or early January. So we are getting interview notice at least 4 months in advance, but unfortunately, because of this COVID and the closing, they're not able to give us quick interview dates. USCIS offices are reopening everywhere, but they are controlling the traffic of clients, of applicants coming in. They are because they don't want, as everybody knows, there has been a surge in the COVID count everywhere, and they just want to make sure that it doesn't go out of hand, and that's the reason USCIS offices are slowly opening up. But one thing we have observed, there is a lot of delay in not even in the processing of the cases, but even in the receipt of the cases. Family cases, employment cases, which are being filed with USCIS, they are taking at least up to 30 days to cache those cases and issue receipt notices. Similar situation is being faced with regard to adjustment applications too. There's a tremendous delay in the processing and receipting of cases by USCIS. So we expect that to continue for a couple of months. Only reason being is that maybe people are not coming in, or they have been asked not to because of this COVID situation. I'll just go back to some other immigration updates. One, of course, is the student visas. The Trump administration had issued a notice saying that if the students were were enrolled only in online classes, they would be barred from staying in the US or coming to the US on student visas, which of course did not go well with a lot of universities. And the universities had sued the Trump administration challenging this. And finally, a week later, they withdrew the announcement. But we are expecting maybe more announcements of policies, guidance by USCIS or the ICE on the student visa situation. Also, we might see people who are like students who are in India right now or abroad, and who are coming to the US for the first time for the fall semester. Mostly, a lot of universities are starting virtual classes, and they're not having in-person classes. So this we are looking to see how the US consulates abroad are issuing the visas to such students, and whether we see any resistance with regard to issuing student visas. This is something we are on the lookout for, but right now, thankfully, the announcement has been withdrawn by the administration. So at least the student visas, the students who are in the US are for now in good position, even though they go for 100% virtual learning, basically. Okay, the last, the one of them is about the recent presidential ban. President Trump had initiated this ban in March, actually, for not allowing certain immigrants and non-immigrant visa workers to come to the US. This was on the basis that we were under recovery with regard to the economy due to the COVID situation. This ban was supposed to end on end of June 30th. Unfortunately, on June 22nd, he went ahead and has extended this ban until the end of the year. This ban essentially means that whoever is outside the US as of June 24, 2020, especially firstly, this ban just applies to H-1Bs, H-2Bs, L-1As, L-1B, J-1s, and their dependents. So this essentially means that whoever's outside the US on June 24th, 2020, and does not have a visa, any of these visas to come to the US, they will not be able to come until this ban has been lifted. So if you have a visa and you're outside the US, you can still come to the US. That does not apply to you. It's only for people who do not have the visa to come to the US. So this mainly affects people who might have gone outside to their home country for a vacation or something, and they were supposed to get the visa stamping done, and then the consulates closed down. It would apply to them too. They would be subject to the ban, and unfortunately, they may not be able to come back to the US. So, and also it also affects the H-1B cap petitions. The H-1B cap petitions were filed by June of this year, and they are supposed to start working for the companies as of October. But because of this ban being in place, even if the petitions were approved for people outside the US, they will not be able to enter until next year. Hopefully, if the ban is lifted, then they will be able to start taking appointments for visa stamping sometime in Jan of next year, and then be able to come to the US. So these are also people who have been issued, who have not been issued immigrant visas. As I mentioned earlier, you can get immigrant visas on the family-based or employment-based. So people who have been waiting for their visa interviews, mostly we are expecting that these interviews will be pushed up till January of next year, because the US consulates in India cannot issue them the immigrant visas for them to come to the US. But if there are certain exceptions to that, and one of them is if any child is aging out, and that child will age out if the visa interview is not done and the visa issued before a certain date, those USCIS may consider those situations and schedule an interview for the child and the family. But besides that, this ban seems to be in place. I don't know if there's a change in administration in November and the new administration does not, suspends this ban, then we are looking forward to it. But this ban actually has resulted, a lot of organizations and employers have filed cases in the federal court against this ban. Also, there are 174 Indian nationals who are on H-1B or H-4 or who are outside the country have also filed cases against this presidential ban in the federal court, and we would see what's the outcome of the case. But right now, this is the situation that's presently in place due to COVID. The last one, of course, is DACA. This is deferred action for childhood arrivals. This basically applies to certain children who were brought here by their parents without any status. Once again, this is for children who don't have any status. So if somebody is on H4 or L2 or any dependent status and is aging out, unfortunately, DACA does not apply to them. So this DACA was implemented in 2012. It was under the Obama administration. And under the administration, it was not giving green cards to the children who did not have status, but it was just trying to legalize them, in the sense trying to get them a work permit, maybe to work here. Some of these children came here when they were maybe 1 year or 2 years, and they had no intent on their own to come here. They were brought here by their parents. So realizing this, the administration at that point of time decided to provide this legal benefit to them of getting work permits so that they could work in the US. They have completed their college, everything. But unfortunately, because they don't have any way of legalizing their status, they cannot work. So the administration at that point of time in 2012 introduced the DACA policy, under which children who met certain, under which individuals who were brought here when they were children and satisfied certain categories, certain conditions, were allowed to apply for work permit as well as travel permit. So at that time, they could apply for work permit. The work permit was issued to them for a period of 2 years, and they were eligible to renew it after when the work permit was expiring. Unfortunately, in September 2017, the current administration rescinded the DACA program, due to which cases were filed in federal court, and finally there were arguments heard in November 2019. And as recent as June 2020, the Supreme Court held that the administration was wrong to rescind the DACA program. Also, Supreme Court has instructed the administration that they should accept new applications under the DACA program. The DACA program had a stipulation that once they had a certain period under which you could apply for the benefit. And if you did not apply for that benefit, you could not apply it in the future. That is what it was. But the Supreme Court stipulated that the administration should now consider accepting even new DACA applications. Unfortunately, USCIS recently in July came out with a memo informing us that they will be denying all new DACA applications, and even the renewal of the DACA applications will be for only a period of 1 year instead of 2 years, which is very disappointing, because we all feel that they are in fact going against the Supreme Court decision. So we are waiting to see if there are any other cases that we are going to be filing against Supreme Court and against the administration because of their new memo. That's all I have for the updates on immigration. I see some questions here by the members, and I will try to answer them as best as I can. But if you would definitely have any follow-up questions, please feel free to email to me. The association has shared my email details and my contact details with you. That is my phone number. You can always call me or you can always text me at that phone number. And you can of course email to me anything that you need, any follow-up questions that you have. I think this one is by Mr. Chandrasekhar. If the child ages out of parents' GC process due to long waiting period, what are the available options? Okay, Mr. Chandrasekhar, right, if your priority date is not current right now, there is nothing much we can do right now, but I think you have taken the step of converting the child's status from H4 to F1, right? Okay.
You can unmute yourself. Chandrasekhar.
Yeah, I have converted to F1.
Right. Yeah. So basically, I would just wait. For now, there's nothing much we can do. The child will not, as I mentioned earlier, the child will not be eligible for a DACA application. The only reason being is that the child is not in the US without status. DACA is specifically for children who are in the US without any legal status. I know it doesn't make sense, but that is what it is basically. So because the child has been in the US with status, DACA would not apply to the child. So you took the right step of having the child convert to F1. The only thing I would say is once your number becomes current.
Go ahead then.
Yeah, once your visa number becomes current, at that point of time, we can then see whether the child is eligible for the provisions under the Child Status Protection Act. That is the only time that we can really make a decision and see whether the child is eligible. And if the child is eligible, of course, you can go ahead and file the I-485 under the CSPA along with your applications. But until then, there is nothing much that we can do for the child right now. I would just say let him or her follow be on F1, and after that, hopefully get on to OPT and H1B and everything. But whenever the visa numbers become available, of course, you can reach out to me and see if the child is eligible under the Child Status Protection Act, and I can definitely advise you at that point of time.
Thank you, Madhavi. Thank you very much.
Okay. The next question is from Satya. So basically, Satya, you say that your wife her biometrics were completed, but your wife is waiting for H4 visa stamping, and looks like the appointments is showing Feb 2021. Satya, because since you are on H1 and you are not subject to the presidential proclamation, as per the information provided by USCIS, your wife also would not be subject to the presidential proclamation. I'm not sure what the situation right now is with the consulates in India. I know they were not. They are slowly opening up. Some of the consulates are opening up, some are not, depending on where you are from. And I would just suggest that maybe you can send an email to the consulate and see whether they are if the consulate is open, of course, because if it's still closed, there's nothing much you can do and we'll have to wait for the consulate to open up. But if the consulate is open, you can send an email to the consulate and advise them that she is not subject to the proclamation because you are not subject to proclamation, and that's why you're requesting for an early appointment so that she can be her visa interview can be completed and she can be issued the H4 visa stamp. Okay, the next one is from Arun. I have approved I-140. Arun, just one question. You said what is your priority date?
My priority date is March 2010.
Oh, okay, it's 2010. Yeah, you mentioned as 2020 and said 10 years ago. Okay, so your priority date is March 2010, and you are under which category? EB2?
EB2, yes.
Okay, so under EB2, I was just looking at the dates right now.
I think it's somewhere in July 2009, if I'm not wrong.
Yes, it is July 2009, year March 2010. This time, actually, the numbers for the month of August and September will move much quickly. The only reason being is that effective October, the new fiscal year starts for the visa numbers. So that's the reason they try to move the dates faster, and they don't want to, because if you do not use up the visa numbers as per regulations, those visa numbers would lapse and it would not be carried forward to the next fiscal year. So that's the reason you will see a faster movement for August and September. But October, there is again that the numbers might go back again. That's what it is. So yes, I'm not sure. The numbers have been moving really slow in the EB2 category. I think you have been also
Right.
monitoring. And unfortunately, we don't have any information. But I don't know if you can send me an email. I'm just looking out for something from the Department of State, Charlie Oppenheim, who's in charge and who provides some prediction. I can share that article with you, and it might be helpful.
That
But
would be
with regard
great.
to with regard to your change of job, unfortunately, because you have not filed for 485, if you change your job, you will have to go through the whole process again. But the saving grace is that you can definitely use the same priority date of March 2010.
Okay.
That's but whoever your new employer is will have to start your entire process right from labor certification.
Got it. My only question is that would there be a situation if suppose my current employer or the previous employer, if I change job, withdraws my green card petition, is that becomes an invalid status, or can they even do that? Because I think
No,
under Obama
actually,
it has become invalid. Sorry, go ahead.
that's right. You're absolutely right, because once if suppose you have the I-140 been approved for more than 6 months, after 6 months the employer cannot do anything about it. Even if they send a letter to withdraw it, USCIS will say that he can no longer do it, because if he has to withdraw it, he has to withdraw it before the 6 months. So since yours was approved in March 2010, there's nothing much the employer can do. It will as if be this, you have this I-140 priority date valid forever right now. Okay. And they will not be able to. So even if you change jobs, your new employer need not start the process immediately. They can do an H-1B transfer and still use the I-140 date of your old employer.
Got it. Thank you.
Okay. Okay. Yeah. The next question is from Anuradha. So you wanted to know if a H4 EAD is pending, should you quit? Okay, as you know, if a H4 EAD is pending and your current H4 EAD has expired, you can't work. So that was absolutely a discussion that you can have with your company and see whether you would just go on leave for loss of pay. That's absolutely okay. As long as you do not get paid and you're not working and you not get paid from the time your H4 EAD is expired until the new H4 EAD is approved, that's okay. They don't really care how you do it, basically. It is not, it's not like an H1B that you have to certain regulations or you have to comply with certain regulations. H4 EAD is an independent benefit that's given to you. So you can go on loss of pay or you can quit. Either one is completely okay.
Thank you. Thank you, Madhavi. That's all I want.
Yeah. Yeah. Potential merit-based immigration impact. Okay. We don't know what President Trump is coming up with about the merit-based immigration, but I think that's going to happen anytime soon. Of course, if he wins the election and he comes over for the next 4 years, we have to wait and see. But right now, I don't think it'll affect the current whoever has approved I-140s. I think going forward is what the new merit-based immigration will impact. Not for people who are already there. So they will still keep the old process in place for people up to a cutoff date, and then they may go on to the new merit-based if it happens. That has to go. Actually, it's not something that can be done by proclamation or announcement. It has to go through Congress and the Senate, so which we think will not happen. So this is on the books for a long time. Right now, we don't see that happening until after the elections. And after elections also, Arun, I think they will definitely have two procedures. That's what we have seen in the past too. When they change from an old procedure to a new procedure, they keep the old procedure in place until the effective date, and then they start the new procedure. So they won't just scrap the old procedure and scrap the I-140 approvals of people who have had it for such a long time.
Thank you. That helps.
Okay. With regard to F4, we're talking about brother sister of a U.S. citizen. So India right now, their priority dates are November 2005. So we are looking at almost 15 years waiting period. So that is the current waiting period for the F4 category. will there be any changes expected in the status of green card holder getting into naturalization? I know President Trump has been talking about, having a stricter procedure for naturalization. But as of now, we have not seen that. We have not seen any other memos or anything else to that effect. But one thing that they are looking at is public charge. They are looking to make that a part of the green card process as well as the naturalization process. Green card process, they've already made public charge part of it. They were trying to implement it last year, and then the case went to federal court. Unfortunately, federal court sided the administration, and now there is, when people are filing for I-485 application, there is this almost 20-page form called I-944 that people have now to file it. If you do not file that form, USCIS is rejecting applications. That form looks at if you've ever, accepted public charge, accepted any financial help from the US government or the state governments. And also it makes sure that you have health insurance. If you're applying for if somebody's applying for adjustment of status, they need to make sure that they have health insurance. These are the grounds that the USCIS may deny the 485 application. So they've already made this a part of the green card process, and maybe in the future, if they want, they can make it a part of the naturalization process. Besides that, I don't see any other substantial changes. Of course, in some states, the naturalization process, which used to take around 6 months, is now taking up to 2 years. So if you're eligible for citizenship, I would advise you to file as soon as possible, because that period now is going up. Earlier, we used to see citizenship interviews in 6 months, and nowadays we are seeing interviews in 2 years. So there is definitely a big delay in N400 applications too. Okay, there are delays in H4 EADs. I see there will be follow for USCIS employees. They say, how do you see this going to impact non-immigrant visa holders? Yes, there are, you're correct, Sarvanan. There is a delay for H4 EADs. H4 EADs can be filed only within a 6-month period. You cannot file it beyond the 6 months, because if you do, USCIS will reject those applications, or they may deny those applications. Yes, we are already seeing there's a huge processing delay, as I mentioned earlier, with all the applications. So with regard to H1Bs, yes, you have the option of filing of paying the premium processing fees and filing those applications. But the other ones, there is nothing much we can do about it. There are certain ways, for instance, in H4 EADs, if you have filed for H4 EAD and it has been pending for 4 months or so, or maybe 5 months, and your current EAD is expiring, maybe you can request for expediting the application on the basis. The only basis I see in such cases is severe financial loss. And sometimes you can explain to the officer that, if the person is working on H4 EAD, they will lose their employment, they will lose a salary. They may, if they are getting health insurance from the employer, they will be out of health insurance. Or if the person the person's driver's license is going to get expired. So these are certain situations that you can put in your request for expediting. But the request for expedite is the only request I can think about. There is nothing much except to wait till for process, because USCIS is not required to process application with a certain time frame, and we can't hold them responsible. So yes, we are going to be seeing further processing delays in a lot of these applications. And the only thing I would suggest, which I've been asking my clients to also to do, as soon as, like for instance, H1B extensions, H4 extensions, H4 EADs, file within the 6-month period. File as soon as suppose your H1B expires December 31st, you are eligible to file as of July 1st. So file as early as possible so that you have sufficient time. The H1Bs can be upgraded, but even if you pay the premium processing fees, the H4s cannot be processed under premium processing. USCIS has been pretty clear about that. The premium processing only for H1Bs. So I would just suggest that you just file as soon as possible. And if you're nearing the H4 EAD expiration and your H4 EAD spouse needs the EAD, then maybe you can request for expedite and provide the circumstances to the USCIS. Okay, once we get the GC in EB1, can we change jobs immediately? We do not advise clients to change jobs immediately because this may be questioned in your citizenship application. Of course, if you change jobs, nobody will know. USCIS has no track of it, nothing with that. But it can be revisited in your citizenship application. So we would suggest that you continue working in the same position at least until for another 6 months. However, if you have been working with that same employer on 485, then if you get your green card and then you change jobs, we don't see a problem with that. The only problem we see is that you immediately change jobs without even working for the employer. Then that might be an issue, and that might be questioned at the time of citizenship application. But of course, you can satisfy the officer, or the company shut down, or you were laid off, or the financial position was such that you had to quit. Then those are something that the USCIS officer may consider. But just keep in mind, if you're looking for citizenship, just try to work at least 6 months. If you're on 485 for 6 months, I would suggest then if you get a green card, you can definitely, quit your job or change jobs basically. Okay, what happens to SSN benefits if a person moves to India for good without green card, but he has contributed to SSN for 10 to 15 years? Okay, Kalpana, I will have to look into this, but from what I am, what I recollect is that only it's a US citizen, they are eligible for those benefits anywhere in the world. If the US citizen moves and settles down in India or any other country, they can still claim those benefits. It's not a problem. But with regard to a person who is not a US citizen, I will definitely have to look into it and see whether I can answer you more properly. My H-1B is expiring August 15. Will USCIS follow the effect? Okay, Arun, if your H-1B expiring August 15, 2020?
Yes.
Okay, and so you are not considering premium processing for some reason?
Yeah, so basically my employer is trying to not process that, and I'm also told that typically with premium there are more cases of rejections. I don't know. I don't know if that's a mindset too.
Okay. Yeah. See, I would just keep a track. It's fine, not a problem. Yes. I don't. When was your H-1B filed? Extension filed?
My H-1B extension, they are planning to file it on Monday actually. Oh,
they haven't filed it yet. So yeah. You're filing it really close.
Right.
Okay. Okay. So yeah. Oh, definitely. Actually, I don't know which service center is the H-1B extension being filed at.
I don't know, but in the past it has been done on Vermont Service Center.
Where is your company based?
My company is based in College Station, Texas.
Oh, in Texas. Okay, so Texas, if they are based in Texas, then it will go to Texas Service Center. Unfortunately, we are seeing a lot of processing delays from Texas. Vermont, I'm seeing, even with all the situation right now, some of the cases that have been filed under regular processing have been approved in 3 months, to tell you frankly. But Texas Service Center, even though some cases that we have filed under premium processing have not been approved in 15 days. So actually it is, they are filing it really towards the fag end, as I said. But yes, I would agree. Means because the only problem is that if a case is denied, then you are kind of stuck because of all these the presidential proclamation and everything else. So yes, because your H1 is expiring, it's better to just file it regular and let it take its time. Correct. So that you have still 40 days that you can work without an approval. Correct. So that should be okay, and then based on how things go, you can make a decision what you want to do. But correct. Yeah, because I wouldn't at this point of time, especially because it's Texas, I've not had very good good feedback from Texas. So Texas is not a very good place.
But with the furlough, do you think there could be further delay? Because yes, I think this current situation is without the furlough itself, right? But there's a strong rumor about furlough that's going to happen.
Yeah, I know they're saying, but I don't know. I know they're waiting for the federal government to fund them, or provide some funds, which I don't know if it's happening or no. But they came out with a new yes, I think on Friday they came out with information saying that they're going to be increasing their fees now, which is going to be effective October 2nd. So we need to see how things are going. But Texas Service Center, to tell you frankly, I have seen cases taking 7 months to get approved also. So, so I would just suggest, as of now, just to apply and sit tight, continue your work,
Sure.
because legally you can work up to 240 days. So that should not be a problem. And,
Sure.
See how things go out with them, basically.
Sure. Thank you, Madhuri.
Okay. Yeah. Can a person possess farming land in India if he becomes a US citizen through naturalization? I think there are restrictions on possessing farming land in India if you're a US citizen. But this is a question I will not have an answer to, because this is related to the Indian laws. So you would need to consult somebody in India who might be aware of that, because even for registration and all, as far as I understand, you need a PAN card, you need documents, maybe an Indian passport or something. And once you become a citizen, essentially you have to apply for cancellation of your passport. Because if you don't do that, then in the future, you may have issues with getting an Indian visa or the OCI card to go to India. But I don't know if there's a way that if you are an OCI card holder, you might be able to own farming land or no. That is one thing I've not explored, but maybe that is something that you may have to talk to somebody in India. They are the ones who might, because once you buy a land, they, what are the requirements, what are registration requirements, they might be able to answer it for you. I think OCI might allow you, but I'm not very sure again. So I can make a note for myself on that, but and try to get back to you on that about the farming lands in India. Okay. If the H-1B is denied, will it impact GC processing? Can one apply I-485 in India? Can H-1B holders legally allowed to work in more than one job? Okay, let me go back to the second question. H-1B visa holders legally allowed to work in more than one job. Suppose I don't understand. Is it for the same company or different companies?
No, different companies.
Okay, fine. So if you're working for two different companies, then the second company has to file a concurrent H-1B. If they file a concurrent H-1B and that is approved, then definitely you can work for both the companies. But you have to be holding two separate H-1B approvals from two different companies.
Got it. Thank you.
That's how they can process your payroll and everything else. With regard, if your H-1B is denied, your I-140 doesn't have any impact. As long as your employer is still willing to process it. You don't apply for 485 from India. The procedure is different. It's called visa processing. So basically the I-140 will have to be routed to the National Visa Center. National Visa Center will take care of all the documentation and everything else. And then the case will be sent to the consulate in India. And the consulate in India, the US consulate in India, will then schedule an interview for you and your family members. So as long as your employer is still willing to process your green card, they don't have to do anything. The H-1B denial will not affect the I-140 petition at all.
Okay. So Madhvi, just to clarify, so again, this is just to think about situation. So
Sure.
If it gets rejected and say the priority date becomes current, at that point in time, one should apply to the National Visa Center.
No, you don't have to. See, basically, at that point of time, Arun, I would suggest you send me the copy of the I-140 approval, because,
Okay.
if your employer has said you're going to adjust your status in the US, then your employer will have to file a form called I-824 to request the USCIS to transfer the approved petition from the USCIS to the National Visa Center.
Okay,
so there's a specific form that has to be filed, because without that form, that case will not be transferred to the National Visa Center.
And this should be done only when the priority date becomes current, or even before
It
that?
can be done before that. If suppose, for instance, touch wood, it doesn't happen. But suppose, for instance, your H1B is denied and you decide to go to India next couple of months, they can immediately start the process. They don't have to wait for the priority date to be current.
Got it.
Yeah.
Thank you.
So the process is a little different, but yes, it is not going to affect your I-140 as long as your employer still has the intention of permanently employing you in the future.
Okay, got it. Thank you.
Okay.
Yeah.
Okay, I don't know. Okay. I was in the EB3 and NMO EB2 priority dates are ahead than EB2. Can I apply for 485 based on EB3? I don't know if your petition is still there on EB3. You definitely can go ahead and file that I-485 on the EB3 if the EB3 dates are current. That's not a problem. But you can't file under EB3, and then if suppose the EB2 dates become current, then you can't file under EB2. You'll have to pick and choose.
Okay, because I was of the understanding that once you move, once they apply move EB2, the EB3 is no longer, it becomes void kind of a thing.
No, but it's two separate. It's two separate applications. See, there are two separate positions. One is an EB3 position and one is an EB2 position. They don't have. So basically, if your employer thinks that EB3, they might have not cancelled it. Yes, I understand. You're just using the EB3 priority date, and because otherwise you will not be able to meet the EB2 position. The EB2 position is completely different, and the EB3 position is completely different. So if you still have both the approvals, and suppose the EB3 becomes current, the date becomes current that you can apply for 485. And if your employer is ready to proceed with that, you can definitely file your 485 application under the EB3.
Okay. I think the only thing is that the I-485J or the supplement, some supplement document that has to say that this is applicable for EB3, right?
No,
I think that
I-485J does not come into effect unless you're changing jobs. So suppose you're working with your employer right now, and the EB3 becomes current, and the EB3 has been filed by the same employer. You can go ahead and file the 485, because when you're submitting the I-140 approval, you're going to be submitting the EB3 I-140 approval, not the EB2.
Got it. Thank you.
So they will be going with the EB3, and after 485 is applied, after 180 days, if you decide to change your job, you can go to a new employer. The employer you have to just file the I-485J to inform the USCIS that you have now changed employers. But that can happen only after the 180 days are expired. If you try to change job before 180 days, then of course you lose out on the 485, and you just have to refile the I-140 itself.
Okay, this is 180 days after we applied for the 485, right?
Yes.
Got it. Thank you.
Yeah, as long as your 485 is pending for 180 days or more, you can move jobs, and you can still you don't have to file a new I-140, nothing, and you can just proceed with the 485.
Got it. Thank you.
Okay.
Okay. Yeah, that's good. Yeah. Move on. Sorry.
Okay. How easy is it to switch fields after I-140 approval? Example, manufacturing to data science. I'm assuming that this is a question regarding H1B and not the I-140. Praveen. So I believe that H1B. See, your I-140 is already there. So basically, whenever the I-140 becomes current, they can of course process you for the I-140. But when you're filing the 485, the company has to still say that you still confirm that they are employing you for that particular position that they filed. Even though your H1B may be in a different position right now, but they still have a requirement for somebody in the original position that they filed the I-140 for. So I don't know if that's your question for it.
No, actually, my question was just to understand a general field switch, when it can be done, and then I was just looking for the right time. Current scenario is H1B. I'm an H1B, but the I-140 approval is just. I-140 submission is going on.
Oh, submission is going on. Okay. Okay, so your I-140 is not yet approved basically, and you're waiting. I would definitely wait for I-140 approval to be done. Once your I-140 is approved, then maybe you can think of switching your positions on the H1B. But as I said, once the I don't know in the future what will happen, because you're still looking at a long time for your I-140 visa numbers to become available. So, if you want to make a switch, you can make a switch. But in the future, again, if you switch an employer, then you would again have to go through the entire I-140 processing, which would take you time. And then again, you have to provide documentation to show that you have the experience. So I'm not sure whether that's the right thing to do for you right now, basically.
Okay, thank you.
Yeah. Okay, Arun, it's the same. It's basically the same thing. Your GC, your green card process is something that is independent of the H-1B. So if you change roles in H-1B, that is fine. It will not really impact your GC unless, and the I-140 employer will have to confirm that they still need somebody for the position that they filed the I-140 for. That's it. So they can still say that you will be employed in so-and-so position, even though your profile might be completely different right now.
Got it. Thank you.
Okay. Why are there so many H1 rejections on those renewing? Had to send back many of my IT contractors this past year. Yes, Sundar, we have been seeing that. Actually, one thing is that USCIS had come out with 2 memos about employer-employee relationship and contractual documents. At that point of time, we could not provide it. Those 2 memos there were suits filed in the court against those 2 memos, and those 2 memos have recently been rescinded. But yes, at that point of time, we saw a lot of rejections and denials by USCIS because those memos clearly said that they wanted us to provide the client letters, they wanted us to provide all the documentation linking all the companies involved. So when there's a employer and there are 2 vendors and then an end client, they wanted all those contractual documents. So that was a major thing that led to a lot of denials in the past. And now the court has come out saying that USCIS should not be asking for it, and USCIS are now rescinded those memos. But because of those 2 memos, we saw a lot of rejections happening, because sometimes we could not get documentation from the end client. End client was not ready to give us letters, and when the memo clearly said that, USCIS would take that as a pretext to deny cases. And that's a reason, even though I myself have seen people here for 10 years and they're just going for renewals, those cases also unfortunately have been denied, and people have had to go back home. So we have no control on those, and it's basically USCIS. But we are hoping now, because of these 2 memos that have been rescinded, we are hoping that USCIS can no longer push us and no longer reject cases saying that we have not provided client letter, we have not provided contractual documents, because now that is not required at all as per the recent USCIS memo. Okay.
Thank you, Madhavi. Appreciate it.
Yeah, you're welcome. Is there any updates on the H4 EAD card printing delays? Is there any alternative? The EAD card does not arrive before the current EAD. Ajit, as I mentioned earlier, if you have filed your each H4 EAD application has been filed well in advance, it's been pending for 4 months or so. The alternative I've seen right now is that I've written to USCI. Basically, you can request and you can put in a request for expediting the application. The way you do that is call the 800 number, and you have to put in an oral request for expediting. They will take all the information in, and then they will send you an email and ask you to provide documentation supporting your expedite request. And you are supposed to respond within 48 hours of receiving that email. Sometimes I have been successful in getting it. Sometimes they don't, even after providing them all the information, USCIS is not inclined to expedite those cases. One recent case that I saw was that where an H4 application, extension application, and an H4 EAD has been pending. USCIS has now advised me that because the biometrics were not completed on the H4, they will not be able to process the H4 EAD application. So there are some things. That happen. There are some things we can't do anything about it, because yes, biometrics were not completed because the ASC test centers were closed down. But with regard, if it's only an H4 EAD application, I would suggest that maybe you can definitely try and call the USCIS and put in a request for expediting. The only ground I see under there are 4 or 5 grounds for expediting an application, and the only ground that I see is, we might be eligible is for severe financial loss. So that's the only ground I've always put under, because the others really don't apply to any of the cases that I'm handling right now. So that is your alternative, that if the card doesn't arrive, maybe if it's 4 months since processing, I'm not sure how long ago you filed it, but that's the reason I always advise clients that file it, as soon as you are eligible to file it, because of these processing delays that are happening right now.
Hey, Madhavi, sorry for the interruption. We will answer Venkat question, then we'll stop. Is that okay with you, or?
Yeah, that's fine, no problem.
Okay.
I think that after Venkat, there's only one. We ever see the
Yeah.
Oh, okay. Yeah, there's one more. Ajit, was just a follow-up. Ajit, basically, so you're saying you received the approval, but waiting for EAD card to arrive. So I'm not sure when you received the approval, but if you have received the H4 approval, then maybe your EAD card should be processed pretty soon. Then I don't see any issue. But even if your EAD, if you think your EAD card is not going to come on time, you can definitely raise a request for expediting the process, as I said, on severe financial grounds. Okay. My L2 is expiring in Feb 2021. My EAD validity is till November this year. I've sent request for renewal, considering my renewal valid. Does EAD renewal happen for sale, or I need to wait for L2 renewal and then apply for EAD renewal? Okay, I've sent request for renewal of EAD. So basically, Venkat, you're saying that your EAD is expiring in November and you have requested for renewal up to February 2021, right?
Right.
Okay, and you have and you have the L2 visa in February, so they don't have you. They should be able, but it's just like from November to Feb, 3 months. I think they will renew your EAD for 3 months, because that's the maximum you will get right now. Okay. Why? But actually, you could have also considered just filing for the L1 extension, right?
That is done by my spouse company. So okay. Actually, they are taking the L1 renewal by November. So
in November, okay.
Yeah.
I don't see. Basically, you're right. You have your L2 valid till February, so you're requesting for the remaining period, and USCIS should be able to. I know it's a short-term EAD, but maybe because you've paid the fees and everything else, they should be able to process your case. I have not come across such cases, actually, to really frankly. 3 months EAD, but from as per the regulations, they are required to.
My concern is that where the USCIS has a time frame like where they have to stamp for minimum 2 years, or they have options to provide EAD for 3 months, like this.
No, there's no regulations that say that you can issue EAD only for 1 year or 2 years or anything like that. They have to issue EAD if they're eligible. I don't know why they issued a short EAD. I'm not sure about that. Firstly, why did they issue till November 2020? Was there an error that they did?
No, I have came to US on April 2018, and after that I have applied for EAD by May, and then they gave an EAD copy to me by November 2018. So basically, okay. It has given for 2 years.
They give you, that's why they give it to EAD. Okay, fine. Yeah. So yeah, I would just suggest that you can definitely. I don't think they will wait for the other one. You're filing on the basis of your current L2 visa. They should be able to. But there are processing delays, so I'm not sure whether they will really get your case or not by then. But whenever your spouse applies, of course, you have to just go ahead and reapply at that point of time again. That's what you have to do.
Okay. Thanks, Madhavi.
Okay.
Thanks.
Yes, I think that's it, Senthil.
Yeah, that's it. Kalpana, are you unmuted?
You're on mute.
Yeah. You are muted. Kalpana. Yeah.
All right.
Thank you, Madhavi. Yeah,
it's me. Hi. Thank you so much, Madhavi. Very, very, very informative. Thank you for answering patiently to every question with so much detail. Oh my God, it was awesome. Thank you. And it was
thank you
to you. And we will give your contact information to anybody now. Like, at least we have a go-to person now. So thank you so much. We appreciate your time and your effort to make this happen. Thank you.
And yeah,
Oh,
this is the first time we are doing through online, because we have not been contributing much for our members. I think we tried this, and it really turned out to be a very great event. Thank you for all your efforts, and I thank all our members for being having this session as a very engaging one. Thank you everyone, and thank you Madhavi for all your great answers and details. Thank you.
And communicating with the members, and it was great. We didn't expect this. It was a successful event. Thanks, Madhavi. Thanks for everybody for asking all your questions. And thank you so much. It was a very good session.
Sorry, guys. We wanted to restrict because of the time constraint. Otherwise, we can spend. And sorry.